Good morning to you all. Welcome along to this morning's webinar. My name is Sam Peacock and I'm the Business Development Manager here at Landmark. So this webinar today is going to focus on consumer protection regulations and how they affect estate agents. Hopefully you'll find this useful. Please feel free to contact me afterwards if you need me to explain anything any further. The issue of consumer protection regulations has risen to greater prominence more recently, with compliance failures being cited in decisions made by the Ombudsman schemes, trading standards cases, and even the Advertising Standards Authority. It's not just the solicitor's responsibility to be providing this information, it is the agent's responsibility from the outset, even before any decision is made. So the purpose of today is providing a grounding in the regulations and go through some real-life examples that agents have faced, and also to look at what lessons can be learnt from these. So we'll start with the introduction of the CPRs. So the Consumer Protection from Unfair Trading Regulations, and to make it short, I'll keep referring to these as CPRs, they superseded the Property Misdescriptions Act. The PMAs were relatively long-standing. They required agents to be truthful about the property, but placing the onus on the buyers to ask relevant questions in order to uncover anything untoward. Agents and vendors were protected under a clause known as caveat emptor, or buyer beware, as some of you may know it as. The CPRs are a wider reaching piece of legislation covering the purchase of consumer goods and services, things like TVs, subscription services, events and so on. They were brought into effect in a state agency with the repeal of the PMAs in 2014, and they apply to both sales and lettings. The CPRs state you must show reasonable steps of due diligence to share important information that would influence the decision of prospective purchasers and tenants. Critically, the liability for establishing this information lies with both the estate agent and the vendor, and it applies to both sales and lettings. It's worth just quickly reviewing how the regulations interpret certain phrases that crop up. So we're just going to look at some definitions here. So material information, the information which the average consumer needs to take an informed transactional decision. The average consumer, so an average consumer is reasonably well informed, reasonably observant and circumspect, but would not be expected to read reams of contractual information or small print. A transactional decision. This means any decision taken by a consumer, whether it is to act or not, concerning whether to purchase or rent a property and on what terms. Misleading omissions. So the omission or deliberate obscuring of information which could affect any decision to buy or rent. Information provided is deliberately unclear, unintelligible, ambiguous or untimely. And as a result, it causes or is likely to cause the average consumer to take a transactional decision he would not have taken otherwise. And lastly, misleading action. A misleading action concerns information which is false and untruthful or is inappropriately presented in such a way as to deceive the average consumer, even if the information is factually correct. A misleading action may cause the average consumer to take a transactional decision he would not have taken otherwise. There is some ambiguity as what might be important for one purchaser, maybe not for another. In most cases, a common sense approach is best. For example, if the purchaser advises they are looking specifically for freehold property rather than leasehold, then this is information which would affect their decision to buy, and therefore it should be investigated. If there is land to the front of the property, it's best to investigate whose responsibility the land is. Is the council responsible for it, or is it the homeowner? If you're letting a flat, it is worth investigating whether the flat comes with parking, and if so, where. This may influence a tenant's decision. The regulations expect you to have done what can be reasonably expected. This does not extend to costly or intrusive investigations such as surveys. In many cases, you will be reliant upon the incumbent vendor, tenant and/or landlord, but as with all compliance, the best thing to do is err on the side of caution. Have a process in place for asking the right questions and documenting the responses, ensuring that responses are appropriately signposted in your particulars for those interested in buying or renting the property. You may wish to undertake your own investigations. You may well be getting some of these documents are part of your AML processes, so you could investigate such resources as the title from Land Registry, which outlines the tenure, covenants and restrictions, and often outlines any boundary queries. You could look at the boundary plan from Land Registry. If the property is leasehold, you could get a copy of the lease from the Land Registry, and that outlines the length of the lease. Again, if the property is leasehold, you could establish who the management company is and what the ground rent and any other rents would be. You could use a fact-finding questionnaire to ask relevant questions. Or you could use the forms used by the solicitor, like the property information form and the fixtures and fittings form. This would have the additional benefit of getting your vendors a step ahead in the transaction. Property Mark's Primary Authority Advice is a good resource with lots of examples outlined on their website, and the National Trading Standards Estate Agency team also provide advice on their website. There are commercial realities with property marketing. If your property particulars detailed every issue with the property, you may well not get any interest at all. That said, you are required to update your particulars if something is established in the course of marketing the property. So say, for example, the sale falls through because of a damp issue. This is material information, and any future prospective purchaser would need to be informed of this. The CPRs are officially policed by the National Trading Standards Estate Agency team based at Powys Council. But CPRs is not their only responsibility, and by their own admission, their resources are finite. But what you tend to see is CPRs are being policed by those who complain. We are seeing people dissatisfied with the service and redress they receive from estate agents, taking their grievances to their own local council trading standards team, the ombudsman schemes, and in some cases to the advertising watchdog, known as the Advertising Standards Authority. Recent press includes the Property Ombudsman's annual report, in which it outlined an average award of £532 to aggrieved customers of estate agents, where the Ombudsman upheld their complaint. For a lot of agents, depending on where you are in the country, this could account for up to 50% of your fee, so it is worth taking seriously. In some cases, the greater damage is to your reputation, especially where your competitors are in a position to take advantage. The Ombudsman outlined 4 key reasons for complaints against estate agents: communications and record keeping, marketing and advertising, instructions, terms of business, commission and termination, in-house complaints handling. And here is where most agents come unstuck. You must record the information too, because in the Ombudsman's eyes, if you didn't record it, it didn't happen. And that is where a lot of agents trip up. They argue a buyer was told about something, but they have no evidence of this. You also need to think about what is important material information to that particular purchaser. If they require a 4th bedroom and that loft isn't really a 4th bedroom, make sure it isn't advertised as one. I imagine you can all think of times where a buyer has pulled out of a sale because of something that they really could have been told sooner in the process, and it would have saved that sale. So we're now going to have a look at a couple of case studies of CPRs in action. So the first one is, should the agent have known about local development? A purchaser bought a property with field views, only to find that once the purchase had completed, there was a 16-acre substation set to be built obstructing those views. The agent claimed to be unaware of the development. However, further investigation revealed that the issue had caused local uproar and had been debated extensively over the previous 2 years, including in local press. The agent had recently sold another property in the vicinity, and the agent had sold a house belonging to the leader of the group opposed to the development. So what was the outcome of this? In a decision that may have repercussions, the Ombudsman concluded that the agent was, or critically should have been, aware of the development, and therefore was in breach of the CPRs in failing to disclose the information. Any notion of an expectation to know what is happening locally, it is dangerous from the agent's point of view. Local knowledge is one thing, but an intimate knowledge of local planning would seem to be grossly unfair. In previous judgments, the Ombudsman has acknowledged that there is no expectation on agents to interpret or undertake investigations requiring legal training. So the grievance was upheld and the award made was £1,000. The next one, and this is probably one you have probably come across quite often, when is a loft conversion not a loft conversion? The buyers were specifically interested in a 3-bedroom property and had made this clear to the agent. The property in question was a 3-bed property, but one of the bedrooms was a loft conversion. Once the survey was commissioned, it revealed that the loft conversion didn't have a building regulation certificate and therefore could not be classed as a bedroom. Furthermore, the surveyor could not confirm whether the conversion had been constructed to the standard required to achieve a certificate. As a result, the buyers pulled out, seeking recompense for the unnecessary cost incurred, explaining that they would not have gone as far as putting in an offer had this information been available at the outset. So the result of this was, given the obvious building work undertaken, the Ombudsman felt that further investigation was warranted prior to the property being marketed. The award of £1,000 was reflected of the reimbursement of the survey fee and a small award to compensate the aggravation, distress and inconvenience caused. Lastly, the rights of way subject to CPR. The property was advertised and sold with access to rear parking. With no parking to the front, vehicular access to the rear was accessible via a route over which the sellers had confirmed there was a right of way. Once the transaction completed, the neighbouring property advised the buyers that the access route actually belonged to them and that there was no right of way over the land, preventing access to rear parking. The result of this was, in reaching a decision, the Ombudsman considered what was reasonable to expect of the agent when investigating the particulars. It noted that the sellers had confirmed they had access over the land for 40 years and had signed off the particulars which identified that the property was for sale with rear parking. It also noted that an agent would not be expected to have the sort of legal training required to investigate such matters. In reality, the failure in this instance lay with the solicitor, who should have investigated the right of way given its importance in terms of access to the rear of the property. However, there are ways to undertake an initial investigation. Many agents will be ordering the Land Registry OC1 title registers as part of their investigations into the ownership of the property. The OC1 is split into 3 parts, also includes important details which can be used to inform potential further investigation, including details of access rights. So we have Section A, which is a description of the property, including the details of rights of access or restrictions. You have Section B, which is all about who owns the property, including any correspondence details. And then lastly, Section C, which looks at the charges against the property, including mortgages, restrictive covenants, and so on. An investigation of Part A of the OC1 could have revealed whether or not the property benefited from the access discussed. So in this case, the grievance was not upheld. Clients will dictate what constitutes material information. In the case, a buyer had explicitly discussed with the agent that their desire to purchase a freehold property. Despite seeking assurances from the agent that the property in question was freehold, it was subsequently established to be a leasehold by the buyer's solicitor. The buyer pulled out of the transaction, seeking reimbursement for costs incurred to date, including the survey, search fees and storage. The outcome of this is that in this case the area was well known for long leaseholds, and the staff member dealing with the buyer had 25 years experience locally. The Property Ombudsman took the view that the buyer's specific requirement for a freehold property constituted material information. Taking into consideration that the specific circumstances of the case, it was felt that the agent should have either been aware or made efforts to make themselves aware of the tenure given the importance the buyer placed on it. The fact that the buyers withdrew from the transaction immediately after finding out satisfied the Ombudsman that the agent had provided more accurate information up front, a different transactional decision would have been made. According to NFOP's primary advice, material information in relation to leasehold would include the number of years remaining on the lease, the annual ground rent charge and when it's payable, including the annual service charge too and when that is payable, and any annual sinking fund reserves and when that is payable, if that is applicable. And also the details of any other event-related fees and charges under the lease that are triggered by certain circumstances or events. So the grievance in this case was upheld and the award was £1,100 for the survey and searches, but storage costs were not included. As ever with complaints, the advice is to err on the side of caution. Make sure you are asking the right questions and documenting the responses. You then need to be able to demonstrate you have communicated these responses to those interested in the property. Taking a proactive approach not only ensures you comply and reduce your risks of fines and bad PR, it's also beneficial for your business. More information up front produces better quality viewings, and once you have an interested party, the risk of fall through is reduced because there's nothing to come out of woodwork 3, 4, 5 weeks down the line. How many times have transactions fallen through because of something that could have been clarified at a much earlier point in the process? Most importantly, keep a record. You need to be able to demonstrate you have a process in place for capturing material information and communicating it to would-be purchasers. CPRs present a great opportunity for a win-win-win. The clients who sell their property faster, the agents get paid faster, and the buyer who experiences a smoother customer journey. Compliance in a Box from Landmark is the pay-as-you-go compliance toolkit for estate agents. Our compliance packs give you the tools to ensure you comply with the CPRs and improve your customer experience. They combine a copy of the title plan, the property information questionnaire, and the fixtures and fittings forms into a printable pre-sale pack. Our customers use them in different ways. Some will provide a link to the online version of the pack on their online listing. Some make printed copies available alongside the particulars and take them on viewings. And some use them in their follow-up to viewings. There is a leasehold version also available with relevant questions on the land registry lease included. Compliance packs also include electronic ID checks for vendors and purchasers, with pricing starting from £19.50 plus VAT per property. I hope you found this webinar to be useful today. If you do have any questions, please don't hesitate to contact me on the details here. And if you do have any queries about Compliance in a Box or would like a no obligation trial, please contact me using the details on here. Thank you everyone, and I hope you all have a great day.